ladies and gentlemen. A ruling by the Allahabad High Court has sent shockwaves through the legal community and public alike. In a decision that has left many questioning its rationale, the court has stated that while the accused actions of grabbing a minor's breasts, tearing her pajama string and trying to drag her were undeniably criminal, they did not amount to an attempt to rape. The judge explained that proving an attempt to rape requires showing that perpetrators went beyond the preparation stage and had a higher degree of determination to commit the crime, a threshold that, according to the court, was not met in this case. Well, there are more details to this, but I will cut this short and I'll get you one of the top legal minds in our country right now. Thank you very much, Ms. Indira Jaising, for joining us. Thank you for your time at this point. Very quickly, because I'm told you're also running short of time, I want to ask you the first question. Is this a correct inference of the law? Because one, this is POCSO. Two, this is about an 11-year-old child. Three, it's just the sheer interpretation of the law that's in question. How do you see this?
It has sent shockwaves, I must say, not only with the legal community, but the entire civil society. Now, why? Because as you rightly point out, it was POCSO. Now, you know, the giveaway in this judgment is the fact that this 11-year-old was dragged behind a culvert. Why does a man want to do what he's doing in secrecy? Obviously, it goes beyond the stage of preparation. And I fail to understand how the judge, what evidence does the judge want of the difference between preparation and intent? Okay. Secondly, you know, all definitions have been amended, including definition of rape in the IPC. And, you know, POCSO always had this distinction between assault and penetrative assault. So I think one of the problems is the judge is not aware of the amendments which have been brought to the law post-Nirbhaya in 2012 and has not realized that the very definition of rape has changed. Okay, so definitely this is a judgment which needs to be taken cognizance of. But I can tell you, I see it as part of a larger backlash against the rights of women. And I find it shocking. You know, just a little earlier, we had this judgment from the Chhattisgarh High Court, where the judges have held that in a case where a woman died in the process of rape, after being raped. Why? Because she was married to the man. Yes, it does bring up issues of marital rape, but if you leave aside the issue of marital rape and look at the issue of death, we're entering a new era where we are seeing rape by death. Okay, and yet the judge holds that he cannot rely on the dying declaration, notwithstanding the forensic report, which shows that the woman died of renal failure. And he knew that she had renal problems. And her allegation was that he penetrated her anus. So if you can see a trend, now coming back to the Allahabad High Court, the Allahabad High Court very recently again granted bail to a man on the condition that the rapist marry the raped woman. It goes against decisions of the Supreme Court. It goes against all canons of justice. And there is something very strange going on in this country. I don't understand what's happening, except to tell you that there's a backlash.
No, but Ms. Indira Jaising, I mean, I know you touched upon the Chhattisgarh court, you touched upon the Allahabad court. You know, just sticking to this point, Supreme Court has several times raised these concerns. I mean, there's a 2021 case where there was a similar misinterpretation of POCSO. There's a 2024 case in August 2024 where Supreme Court had set aside a judgment of Calcutta High Court as well. So there have been precedents to this. And there have been series of judgments that have been poorly worded, wrongly interpreted by lower courts. And we have discussed this. This has been out in public as well. Indira Jaising, one is women's rights and women's representation, but it's also about the interpretation of law. There seems to be something appallingly wrong.
This wrong is in the mind of the judge. And by the way, don't call these lower courts. The High Court is a constitutional court. Okay? It has jurisdiction beyond that of a lower court. So something is going wrong at very high levels in the judiciary. This is what we have to take very seriously. What is it that is going wrong at these high levels of the judiciary when it comes to the issue of sexual assault, rape? They don't even understand the meaning of, what is rape. It looks like that. So you're right. It is going wrong, and despite, one of the problems is that the Supreme Court has no methodology to sanction judges of the High Court who misinterpret the law like this. And except
Okay.
on an appeal. Okay. Now the point is, you and I can't file an appeal against this judgment. Okay. When there is an acquittal, we cannot file an appeal. It's only perhaps the family of the victim who can file an appeal, and corrections, if any, by the Supreme Court can only be done in its appellate jurisdiction. This is one major problem. So, for example, supposing NGOs, you, me, we wanted to take the matter to court, we have certain procedural hurdles for taking these matters to court. So this is why personally, I think that the Supreme Court should take so much cognizance of what is going wrong with the high courts, and try to correct it either through their appellate jurisdiction or advisory jurisdiction, so that this kind of trend is reversed.
So, Ms. Indira Jaising, a lot has been spoken about accountability or a lack of it, and it obviously gets interpreted in different contexts very differently. But in these cases, the way the laws have been interpreted, misinterpreted, so and so, do you think there needs to be an internal systemic manner of accountability, of ensuring accountability? Because not everybody has the time and the money to go to run after courts. Anyway, hearing and a system of justice takes a whole lot of time, effort, and a toll on one's whole life or whatever is left. And then to go on further with it, court to court, is not easy. How do you see this move forward?
Thank you for this question. It's a very important one. I agree with everything that you're saying. No one has the time, resources, energy. And let me tell you, there is litigation fatigue in the litigants, okay? So yes, I do believe that there should be systemic, periodic reviews of judgments of individual judges for their sensitivity, for their compliance with the law, and this kind of routine monitoring and evaluation of the content of judgments of the court should be put in place by the Supreme Court of India and be carried out regularly, so that at least they can give guidelines, and I mean guidelines which are legal in nature. I don't mean that they can tell the judge of the High Court how to write a judgment, but an approach. Like, for example, the former Chief Justice of India, Justice Chandrachud, published a gender glossary. We should have publications of this kind by the Supreme Court, which tell you what the law is, and then monitor whether they're complying with the law. I think it's a very important question that you have raised.
Lastly, for people who have been outraging, upset, angry, and even questioning what the court said, do you want to set it on record? For whatever it is, groping, opening up the pyjama strings, dragging a person under, is this rape or is this not rape? I know there are so many other contours and contexts to answer a question like this, but how would you respond to this?
Yes, once again, I have to agree with you. Let's give it a legal name. It's an attempt to commit penetrative sexual assault and sexual assault. The law says it in so many words, so why are we fighting shy of it? I don't get the point. It's an 11-year-old child. What do you want? Do you want us to show you marks of resistance? Is she expected to show wounds on her body before you can expect a judgment which says this was an attempt to rape? What exactly? Let the judges clarify what they mean when they say we want intent to be proved. How do you prove intent? Intent is proved by actions which precede the actual act of rape, because the offense, remember, was not an offense of rape. It was attempt to commit rape.
Right, Indira Jaising, thank you very much for your time. Thank you for your interpretations. And most importantly, we even haven't discussed one very important aspect, and that is just the trauma of a minor or anybody to go through this whole process of justice, which possibly may sometimes not land up in the right hands of justice, may be seen as injustice. But this is in itself a huge, huge hurdle. But Indira Jaising, thank you very much for your time. Thank you very much.
Well, tell me, if children lose faith in the judiciary, where do we go from there? This is the point we're
That's
at
true.
right now.
I think
Loss
that's a
of
question
faith,
that...
Yeah, loss of faith in the judiciary for the children of this country. Where do you go from there?
I just hope we don't reach that. And I'm glad people like you are raising your voice. I think that gives definitely some sense of comfort.
Thank you.
Thank you very much. Thank you very much, Ms. Indira Jaising.